Everyone, and welcome to LIBOR Wednesday webinar. I'm Mary Ann Monteleone, Vice President of Professional Development for the Long Island Board of Realtors, and we'd like to welcome you as you settle in. And we celebrate on our third Wednesday webinar, Fair Housing Month. April is National Fair Housing Month, and each Wednesday we bring in a guest speaker to provide us with some insight and an educational session for realtors. And again, as we honor and celebrate April as Fair Housing Month. Today is a very, very special guest who I reached out to, and without hesitation, she said absolutely. And she looked at her calendar, and this date was free for her, 12 o'clock. And we're so happy to have Dawn Lott here with us. So welcome, Dawn.
Thank you. Thank you for having me.
I want to read this so I get everything right, but today's session is eliminating bias and discrimination in our communities, and Dawn Lott is director for the Suffolk County Human Rights Commission. But I do want to tell you a little bit about Dawn. Dawn Lott is a lifelong resident of Long Island and obtained her Bachelor's of Science from Cornell University School of Industrial and Labor Relations, and her Juris Doctorate from Benjamin N. Cardozo School of Law. As an attorney, the majority of Dawn's legal career has been in private practice, concentrating in matrimonial employment and labor and corporate commercial litigation. Dawn is currently the executive director for Suffolk County Human Rights Commission, where she strives to ensure that the Commission continues to be a vital vehicle for the enforcement of human rights for all of Suffolk County residents. So welcome, Dawn.
Thank you, Mary Ann. Thank you for having me and for giving me this opportunity to speak. And so good morning all, or good afternoon, I should say. Today we'll be talking about really the basics of fair housing and local laws and enforcement, and some of the information that I'll share may sound familiar. Hopefully it will sound familiar. It may not, but first, let me just start off by saying that the Human Rights Commission, the mission really is to eliminate bias and discrimination and to ensure that residents have an equal opportunity to enjoy a full and a productive life here in Suffolk County. We are governed by 15 commission members who meet monthly, and their purpose is really to establish policies to further the mission of the Human Rights Commission. The services that we offer include investigating claims of discrimination in the areas of education, employment, credit, volunteer firefighters, and housing. And we enforce both federal, state, and local anti-discrimination laws. So what I'd like to do is an overview of some of the fair housing laws, and then we'll go into a little later on about what the Human Rights Commission does in terms of its investigations, and then we will give an opportunity for any questions. I believe that feature will be open a little later on in the presentation. So I just want to start off by saying that fair housing laws are not the same as landlord-tenant laws. Landlord-tenant laws cover the general rights and responsibilities of rental tenants and housing providers. Fair housing laws, however, cover the rights of renters and of home buyers to be free from discrimination in their choice of housing and treatment in rental, housing, sales, and finances. So for example, a landlord refusing to make repairs would be a landlord-tenant issue. A landlord refusing to make repairs only for recipients of maybe Section 8 may be a fair housing issue. So let's begin with one of the first federal fair housing laws, which was the Civil Rights Act of 1866. And that act basically declared all citizens without regard to race or color or previous condition of slavery or involuntary servitude brought to America in the wake of the Civil War. It covers real property and personal property, whether intended for residential or commercial use. And it is important to note that it only prohibits racial discrimination. Then you have the Civil Rights Act of 1968, which is also known as the Fair Housing Act, which I'm sure you've heard of. Now, this legislation was the culmination of civil rights campaign against housing discrimination in the US, and it was approved 1 week after Dr. King's assassination. And it was meant as a follow-up to the Civil Rights Act of 1964, which banned segregation in public places and prohibited discrimination in employment based upon race, color, religion, sex, and national origin. So the Fair Housing Act provided equal opportunities regardless of one's race, color, religion, national origin. Sex was added in 1974. When we say sex, we mean gender. And then in 1988, familial status, which is families with one or more children under 18 or pregnant women, and disability were added. So that was in 1988. Now let's talk a little bit about family status discrimination. What are some examples? Well, one example can be restricting families with children to a certain building or a section of the building. And an exception to that obviously would be if there are any health and safety concerns. So a swimming pool, not going in a swimming pool unless there's an authorized adult there. Another example of familial status discrimination could be not allowing children. So if there are ads that say no children or couples only or no teenagers. Occupancy standards to limit the number of families with children are sometimes what we'll see under this category, where a housing provider may claim that a room is a den rather than a bedroom. Now let's talk a little bit about disability. The Fair Housing Act defines disability as a person with a physical or mental impairment which substantially impairs one or more major life activities. And those activities include caring for oneself, manual tasks, walking, seeing, and hearing. Disability is also defined as regarded as having such an impairment, as I just discussed, and also are having a record of an impairment. Now, the Fair Housing Act prohibits the refusal to make a reasonable accommodation or a modification that allows a person with a disability the equal opportunity to access, use, and fully enjoy a dwelling. Reasonable accommodation, what is that? That's a physical change to an apartment or house or common space area that makes the dwelling accessible to someone with a disability, such as adding a ramp, grab bars, widening doorways, or lowering kitchen cabinets. Reasonable accommodation is a change in rule or policy or service needed for a person with disability, equal access to an enjoyment of a dwelling or a common area. If a property is federally funded, housing providers pay for the modification. If privately owned, a tenant pays for a requested modification, and the landlord may require the tenant change or remove that modification upon the tenant's departure. Now, when we talk about reasonable, this should be determined on a case-by-case basis. And some of the factors that are considered is whether or not it causes an undue financial or administrative burden, whether or not there are health and safety concerns, and whether or not the requested reasonable accommodation fundamentally alters the nature of the provider's operation, and then also feasibility. Now, the individual requesting a reasonable accommodation must identify the relationship that there's a relationship between the request and their individual disability. Now, what we here in the Human Rights Commission, what we a lot of times will get are requests or claims that someone was denied a reasonable accommodation when it comes to pets. So let's talk about that for a minute. Reasonable accommodation, when we talk about pet policy. So having a no pet policy is permissible. However, there needs to be exceptions, right? And so one of those common requests that we see is a request for an emotional support, an accommodation for an emotional support animal and or service animal. Now, they perform tasks or provide support to a person with a physical or mental disability and assist with their daily living. This does not mean pets. And it's not subject an emotional support animal is not subject to pet fees. There are no trainings that are required, nor is there certification required. One cannot have a breed or size limitation. Assistance animals cannot, however, pose health or safety threats to other tenants. Now, under the ADA, and that's the American with Disabilities Act, that does not cover emotional support animals, only service animals, dogs, and miniature horses. And a dog is individually trained to perform tasks to benefit individuals with disabilities. There's no requirement that the dog be licensed or certified, and they must be permitted in all areas where public is allowed. So for instance, a hospital, in a patient's room, however, not in an operating room. Documentation that is permissible, documentation that regarding the disability, the need for an animal, but you're not entitled to have the person's entire medical file, and nor can you request the HIPAA, that they waive any HIPAA regulation. So what can you ask? You can ask, does that person or anyone in their household require a reasonable accommodation or reasonable modification? What type of reasonable accommodation or modification does that individual or a household member need? And this information must be kept confidential. You cannot ask, do you or a family member, do they have a disability or the severity or extent of their disability? Now, I mentioned earlier that that sex was added under the Fair Housing Act in 1974. And it's just worth mentioning that in January of this year, President Biden signed an executive order requiring the protection of for LGBTQ people in housing, citing to a case, it was Bostic versus Clayton, which basically prohibited sex discrimination in the Equal Employment Act, so in terms of employment. And that order was extended in February of this year as well. So the Fair Housing Act, it's a federal protection, and it's against sex-based discrimination. So just wanted to mention that. Next, what are some of the issues that are covered under the Fair Housing Act? So if the following is based upon a protected category, then it's covered under the Fair Housing Act. And that would be a refusal to rent or sell housing, refusal to negotiate for housing, to make housing available or deny that it exists, discriminatory advertising, denying access to or membership in a multiple listing service. Also blockbusting, also known as panic peddling, which is the practice of persuading owners to sell property cheap because fair people of another race or class will be moving in and then reselling for a higher price. Redlining, refusing a loan insurance services to someone because they live in a neighborhood deemed to be a poor financial risk, regardless of the economic qualifications of the borrower or the prospective homeowner. Steering, which we've heard a lot in the last couple of years, definitely with regard to, as identified in the Newsday investigation, and that's directing racial or ethnic groups to a specific area to maintain a segregated neighborhood. And having different terms and conditions of a rental or a sale or rules or procedures, mortgage lending, appraisals, and insurance. So what's covered when we talk about housing? What's covered under the Fair Housing Act? Well, that would include single family homes owned by private persons when a real estate broker and or discriminatory advertising is used to sell or rent the home. Single family homes not owned by private persons, such as corporations or partnerships, even if a broker is not used to sell or rent the home. Multifamily dwellings with 5 or more units, including rooming houses. Multifamily dwellings with 4 or less units if the owner does not live in one of the units. And those are housing that's covered under the Fair Housing Act. Now let's move into New York State, or what is known as the executive law. That includes all of the fair housing protected categories that I just mentioned. And in addition, New York State provides for protections for gender identity or expression, age, 18 or over, the exceptions being 55 older units are permissible, and housing discounts are permissible for 65 and over. Also included is marital status, military status, sexual orientation, source of income. As you know, New York State recently was afforded that protection, and that includes, protection for tenants who receive housing subsidies or vouchers, Section 8, SSI. Also included in New York State human rights law is sex, and the exception to that is single-sex housing accommodations. So for instance, male or female dorms are permitted. And when we talk about age, a policy or practice that seeks to bar those perceived of being more likely to vandalize or create noise is prohibited, or a perception that an age group may fall ill or lose a job. So for example, ads that may say looking for quote mature persons, or don't rent to students, would be a possible violation of the New York State human rights law. In terms of the housing that's covered, under New York State, they do provide an exemption for two-family owner-occupied housing, room rentals of the same sex, owner-occupied rooming housing. However, the federal laws may still apply, if not the state. In terms of Suffolk County, we cover everything under the Fair Housing Act, as well as New York State. And in addition, included is veteran status, alienage or citizenship, domestic violence victim. In terms of housing accommodations in Suffolk County, what's covered are housing accommodations with 3 or more units, where the owner has a right to sell, rent, or lease 3 or more housing accommodations. We do have source of income protections. The exceptions are housing units with 2 or less units. And Nassau County also has protections as well, under both the protections provided under the Fair Housing Act, New York State. And in addition, they have ethnicity and veteran status as well. And they also have the same exceptions. So when we talk about fair housing laws, one of the things, the question is, well, who must comply? Well, property owners, property managers, property maintenance staff, real estate brokers or agents, homeowners, condo associations, housing authority staff, housing developers and contractors, mortgage lenders, financial institutions, advertising media, those are who must comply with these various laws. Next, we can talk about the complaint process and how we handle complaints here in Suffolk County. One of the things that should be noted is that we only have jurisdiction for those cases arising in Suffolk County. So if the property is located in Suffolk County and the resident resides here in Suffolk County, however, all claims have to be brought within 1 year of the last date of the Discriminatory Act. The complaints that come through our office are either, especially since COVID, have been via mail or email or phone call. Once we have a complaint that is filed in our office, then it is assigned to an investigator. The investigator initially will attempt to see if there's any attempts to conciliate the matter, settlement. If that is not feasible at that particular point in time, a complaint investigation will ensue, and evidence will be gathered by both parties, both the complainant and the respondent. Once all of the evidence is collected, then the investigators typically will make another attempt to see if resolution can be resolved before making a final determination as to whether discrimination has occurred. If the case obviously is settled, then it stops right there and we draft settlement documents. However, if the case is not settled, what happens if there's a finding of probable cause that discrimination has occurred, then those cases are then referred to our ALJs, and the administrative law judges are responsible for handling the hearings for those housing discrimination cases. and they usually will conduct hearings for about a day or two. Initially, the hearing will probably begin with a discussion about whether settlement is possible. If not, then a hearing will be conducted and both parties are allowed to present their evidence, and then there will be a final determination. Once that determination is made by the administrative law judge, it is then sent back to the office, and a final decision is rendered by myself. In terms of damages, if there has been a complaint that has been founded, probable cause has been determined, the ALJ has conducted a hearing, and there is a finding of discrimination, damages that can be assessed are civil damages up to $50,000. If there's a finding that the conduct was willful or wanton, there's additional damages of $100,000. And then only for housing cases, there is the option to assess punitive damages in the amount up to $10,000. And basically after the decision has been rendered, it is filed, and both parties are served with a copy of that decision. There are opportunities for an individual who is not pleased with that outcome to file it would be an Article 78 proceeding in New York State Supreme Court, and they can do that without counsel, and typically it is with counsel. And that pretty much is what I have to share with you today. And so at this particular point in time, if there are any questions, I will entertain any questions that the audience may have. Mary Ann? I'm gonna see, maybe I can.
Hello.
Hi.
Hi, how are you?
Hi, Alicia. How are you?
I'm well, and yourself. Thank you so much for taking the time out to have this meeting today. I am a realtor in Queens, actually, and I am helping some clients in Westchester County. And I basically submitted an offer. Now, I'm African American as well as my clients, and the agent, the seller's agent, well, I believe she's Caucasian. So we submitted an offer, and we submitted an offer for $715. The seller supposedly countered, and our final offer was $725. So the agent said that, oh, I'm sorry, we have a higher offer. The seller accepted the higher offer. And I was like, okay, thank you for your time. And about, I want to say about 3 weeks ago, actually, I'm sorry, about last week, I see the house is relisted. So how can you prove that someone was discriminating against you without blatantly saying, hey, you know, the seller doesn't want to accept your offer because, you know, we don't want you guys in this area, in this neighborhood, because the area was particularly in Yonkers, it was particularly Caucasian. So I guess I wanted to know, is there any way that I can go about just finding an explanation as to, we submitted an offer and then the house is still on the market without any explanation, I guess.
Thank you, Alicia, for that question. So one of the things that and may I just ask you a question? So how long have you been in this profession?
I've been a realtor for 6 years.
For 6 years, okay.
Yeah.
Well, the reason why I ask that is that this may or this may not have been your first experience, but one of the difficult things when we talk about housing discrimination, one of the difficult things is that typically, and I think this is what the Newsday article or the research really highlighted, was that it's usually not what we call in the legal community a smoking gun, right? So no one says, well, I'm not going to rent to you, I'm not going to sell to you because you belong in a protected category.
Right.
So it's so very discreet. And so,
Yeah.
because it is discreet, a lot of times it's difficult for someone, even if, as experienced as you may be, to really understand what is happening at that particular time. And it's only in retrospect, after you put certain pieces together. And in this particular case, you ended up seeing the listing at a later point in time. So to answer your question, I would say it's not necessarily up to you to prove, but there are agencies like myself, and I know there's Westchester Human Rights Commission. There's also the New York State Division of Human Rights, and other organizations similar to mine who do this type of investigation. So my recommendation to you would be that you should report it to those agencies and let them and their staff do the investigation, right? And I know that that may not be a quick, resolution, because there is a process and time involved with that.
Right.
But that is one way that it may be discovered, because through that investigation, some of the things that we would be asking for are those documents. So those offers, if you said that there was an offer, getting that
Yes.
information, looking at the timing in which that information was allegedly given, given to that particular party. And then you can kind of review that information and see if the timeline really lines up to what it is that they said. Now, I understand that that may mean, that you're moving on in terms of your client, you're moving on,
Right.
and you may not get the home that you wanted. But if in fact there is a finding that there had been some discrimination based upon the race of the party or the potential home buyer, then there is recourse and there are damages with that are, available.
Okay. I will definitely reach out. Thank you so much. But I didn't even say anything. They felt it. They said, hey, Alicia, I feel like she's discriminating against us, because you look at them and he works for construction. So, he makes a lot of money. So it's just, they don't want to move forward. So, I mean, it may continue, because if they don't want to move forward, then, I just kind of have to grant their wish.
You do, but there also is this accountability factor. And so, I'm obviously your client, they make their own determination. But what I will say is that if people don't complain, and if there
Right.
are, then it continues.
Right.
It definitely continues. And one of the things that, I'll share with you is that being an attorney before coming to the Human Rights Commission and representing plaintiffs, not only in terms of housing discrimination, a lot in terms of employment discrimination, what they would say to me, the plaintiffs, is it was just a feeling. It was just a feeling. I can't, at this particular point, I can't put my finger on it. And it was just a feeling. And then as we start to examine, timeline in the course of certain events and gathering documents and then speaking to witnesses, then sometimes in those instances, that feeling was really substantiated by the other evidence that came after it. So sometimes it starts, more times than not, it starts with that feeling.
Okay. All right. Thank you so much.
You're welcome.
Is there any like resource because I'm not sure who my housing department is in Queens.
So you can go to New York City Commission on Human Rights.
Okay. New York City. Okay.
And I don't know if we can put, I was just looking to see if they could put it in the chat, but if you just New York City Commission on Human Rights, or you can do New York State Division of Human Rights, either of those two agencies you can contact.
Right. Thank you so much. I appreciate it.
You're welcome. Yep. Thank you for your question, Ben. Were there any other questions?
It's Mary Ann, Dawn. There are a few questions in the Q&A. What are the exceptions for acceptance of vouchers?
What are the exceptions? I'm not sure if I understand the question. pursuant to the source of income, you cannot deny someone. You cannot deny someone who has a voucher. And so I'm not sure what exception, if I'm not, I don't understand that question.
Yeah, maybe the person
So
can.
maybe whoever if they can either, I don't know if they have the opportunity to raise their hand or clarify in the Q&A.
Sure, sure.
Mhm.
Another question, can landlords credit screen voucher holders if they are responsible for a portion of the rent? If credit is not great, can they reject, I guess, the tenant based on the credit score?
So if it's the housing, if it's partially subsidized, so the potential tenant has to pay a portion of that amount, I believe is maybe the question. And so if they're using a credit check, one, that credit check has to be for everyone. Two, one of the issues that will sometimes come into play is if they're relying upon that credit check, and as a result of the credit check, it's that they're denying that person the unit. If there appears to be a disparate impact in a specific community or a specific group, protected group, then you may run the risk of someone filing a complaint based upon that, right? So even if the intent was not to impact that group, but it actually does, or has a result of impacting that particular group, then there could be a claim of discrimination based upon that. And so you really want to make sure that the reason why you're denying that person, you should definitely be documenting everything, but also making sure you're not utilizing it to eliminate a particular group, because there are presumptions and there are biases that people who are on Section 8 or receive Section 8, that they come from a particular group of a particular race. And so again, you want to be cautious when you're using that as a criteria to deny someone rental or housing. Any other questions?
Yes, that makes sense. Oh, we have one person asking about a specific, the status of a specific property, but I don't think, or a claim. I don't think you would be able to answer that right now. Maybe privately we could, discuss it, or he could reach out.
Okay.
Yeah, that's it for now. I'll keep watching. If you want to stop in a little bit, you can continue. Thanks, Dawn.
Okay. Let me see, is there anything? Okay. Okay, if there are no, if there are no additional questions, I guess one of the things that we can talk about is, because source of income it's not new to Suffolk County. We've had it in our law for a while. I'll just share some instances some cases that we've dealt with in terms of source of income. One of the questions that someone had raised before was the issue of there being someone making an income, so asking about someone's income and how much they earn, and clearly someone who is collecting, who is receiving Section 8 or some other subsidized housing, their income would be far less than, say, obviously someone who's not. And so, and also the fact that if the voucher covers the full rent, then that asking that question would be considered, again, and I'm saying this is on a case-by-case basis, but would be considered, a violation of the law to have that requirement, especially since the housing is 100% covered. One of the other question or issues that we've had in the past is where there's been a landlord who or tenant who's been residing in a apartment complex, and initially when they became a tenant, they were not receiving Section 8, and for a variety of reasons, prior to their renewal of their lease agreement, they have to, they have to renew, and at that renewal point, then they are the recipients of Section 8. And so we've had instances where the claim has been that the housing provider is not renewing their lease because they're now the recipient of Section 8. And so that is a case, those are we've had more than one case with that similar fact pattern. And that is a case, obviously, that we would take and we would investigate. And part of what we would be asking in that instance is looking to see if the housing provider has accepted or has other tenants that are the recipients of Section 8, seeing whether or not, given the time period, were there any other individuals who were denied a renewal. And probably the first question is asking the housing provider why wasn't the lease renewed. And so in the cases that were of that similar fact pattern, we actually ended up resolving that matter. One instance, the lease was renewed for the 1 year period of time, and then in the other case, the tenant had found another place, and so it resolved in that manner. So those were a few of the cases that we've had as it relates to source of income. Any other questions? Okay. Yep, I'm just reading the chats to myself here, so I don't see any questions. But Todd, I see you weighing in. Yes, sure, you cannot refuse source of income, but you can ask for credit. You can do the credit check, and that's with the provision that I just mentioned earlier. Does anyone have any other questions?
One question is, where can we find these educational sessions on LIBOR's site? And it's lirealtor.com/COVID. And that's where LIBOR has all of the Wednesday webinars for replay and, to share. So it's lirealtor.com/COVID. Thanks, Dawn.
Okay. Yeah, and also I should also mention too that a landlord or housing provider cannot threaten someone because they have either filed a complaint with our office or that they've exercised their rights as it relates to human rights law. So we've had instances where the allegation has been the landlord has threatened the tenant with either eviction, or we've had cases where the individual, the tenant is undocumented, and so the landlord or housing provider has threatened to contact immigration services as a result. So that runs afoul of the law, and that is not permissible. And just if I hadn't already mentioned it, to mention that in terms of the cases that we handle, someone's immigration status is not an impediment to them filing with our office. We do take those complaints as well. And so threatening an individual, retaliation for filing a claim or asserting your rights under the law are also prohibited under the human rights law, Suffolk County human rights law as well. Is it logical? Question, is it logical to not renew a lease because the landlord wants to move in their relatives? So that question, it can be logical that they don't renew the lease, but what you want to be mindful of is the reason that is given as to why why the lease is not being renewed. And so if you're talking about housing, a complex, so an apartment complex, and if we're talking about one individual, then that scenario. But if we're talking about a owner occupied dwelling and not renewing the lease because you want to move someone in, well, that reason may be acceptable. But the scenarios that I was talking about, we're dealing with housing apartment complex, so where you have multiple tenants, and so you have to look at the reason that was given initially for the non-renewal. And in the case that I made reference to, it was the timing of it all, which raised a red flag, because the individual had been living there for some years now. I think it was like maybe 6 years. And so it was the first year that they had to get the assistance of public assistance to subsidize their income. And so, and like I said, although the case was settled, one of the things we looked at was to see how many other individuals were receiving Section 8 in that complex, and also looking at the terms of their lease as well. What does it say? What does it say about notification when you're a non-renewal, when you're or even terminating a lease? What was the documentation that was provided? What was the written documentation that was provided in those instances? Can you elaborate? Question, can you elaborate on what types of documentation a housing provider can require in order to verify income or ability to pay rent? I think just so I think one of the things that, if this helps at all, one of the things that to answer a lot of these questions is that you cannot make, you have to treat everyone the same. So when we're talking about the protected categories, when we're talking about race, when we're talking about color, when we're talking about religion, you cannot have separate procedures for those who belong in a protected category versus those who don't belong in a protected category. And if you start from that premise, I'm not saying that there will not be any issues and that there will not be people who will file complaints of discrimination. But if you're treating everyone the same, then that's what you start with. And then when you start to make exceptions, you have to ask yourself, why am I making those exceptions? Are those, and if I'm making those exceptions, do those exceptions negatively or disproportionately impact a protected group? And so those are some of the things that we talk about. So for instance, if you say, well, all of my, every potential home buyer, or excuse me, a potential tenant, this is the procedure that we follow, and you don't deviate from that procedure. Then if you're talking about, and you say there's no policy that says, well, we don't accept Section 8. So when you talk about Section 8, those who receive Section 8 or the subsidized income, when you look at those potential candidates, and if you're treating them, if you're treating them the same, and then if you have provisions there that say, and as I mentioned before, asking someone who has 100% funding, asking them to provide income, or to, excuse me, asking them for income or for even a credit, ask yourself, what is the purpose? If they have a credit, if their credit is whatever the credit score is, 400, or if their income is 25,000, but they're receiving a 100% voucher, what is the purpose in asking for that information? And if you utilize that information, then to deny them, because what are you asking the information for? You're trying to assess their ability to pay, but their ability to pay is the voucher, that 100% that they're receiving. So I hope that that makes sense. What is the reason why you're asking for that information, and are you utilizing it in such a way that it can be deemed that you're trying to prevent a particular group because there may be a perception that they are that they either they can't afford there, or that perhaps that they're of a particular race or particular color or particular religion, and so you may not want those groups in your housing accommodations. Okay, were there any other questions?
I don't see any, Dawn. I did want everyone to know that LIBOR has a fair housing resource hub on its website with the different local and state agencies. For the member who was asking about New York City, everything is there. The latest protected classes, again, different resources on lirealtor.com. At the top of the page, there's a fair housing button that you can hit under legal, and it goes right to the resource page. I know members will find it very helpful and useful, with a list of all of the fair housing documents, the posters, the disclosures, and also a series of training programs coming up. So I wanted them to know about that.
And I also would like to say that because housing discrimination can be very complex, and like I said initially with one of the first questions that was asked, it's not always black and white. And if anyone has any questions, and we've done this before, if you have a question or you have a concern, you're always free to contact our office. While we investigate complaints of discrimination, really, if you first joined, when I said what our mission is really to make sure and ensure that everyone has a right to enjoy living where they would like to live. And so the goal is not to file as many discrimination claims, but it really is to educate people about what the laws are so that they can comply with the laws. And if there are any questions, to have those questions answered before there's any action that will perhaps warrant scrutiny and an investigation. So a lot of times education is really key. And Marianne, I thank you for providing these series as well. And if you look on our website, Suffolk County, you can just Google Suffolk County Human Rights Commission. We have our laws there, and we also have forms there, but also New York State Division of Human Rights as well. They have a whole series of forms and pamphlets that speak specifically to source of income and some of the other housing laws and protected categories that we spoke of today. So I find that picking up the phone and speaking or sending an email has been helpful in many instances. So I definitely encourage everyone, if that's if you have a question, please feel free to reach out.
Thank you, Dawn. I also want to tell everyone listening that the link to Suffolk County Human Rights Commission, Dawn, where Dawn is right on the site as well, as well as Nassau, New York City, and state.
Right. And Nassau too. We have Nassau County is our counterpart. So while I mentioned that our jurisdiction is only Suffolk County, we have Nassau County, and again we have New York State Division of Human Rights as well, and they have offices both here in Nassau and Suffolk County.
Looks like we have one more question, if I may.
Mhm.
There are cases when the agency providing 100% rent for the prospective tenant may withdraw it later. So can the landlord look at the prospective tenant income for renewal if the rent is withdrawn in whole or in part?
I'm sorry, say that a question again, Marion?
It's in the chat if
Oh.
it'll help you to see it. There are cases when the agency providing 100% rent for the prospective tenant may withdraw it later. So can the landlord look at the prospective tenant income for renewal if the rent is, I guess the subsidy is taken away, whole or in part?
Can they look at their income if the voucher changes, so if someone's paying 100%, if an agency is paying 100% and then up for renewal, it may be reduced to
Yes,
50%. Can you look at that?
yes.
Again,
exactly.
you go back to what is the motive is what we would be asking. And so if it's a policy that is being applied across the board to everyone, and if there are exceptions, and if those exceptions are reasonable and are not based upon that person's protected category, then I would say that you have a better chance of defending any claims of discrimination in that particular instance. But you really have to look at the reason why. And I think when we talk about income checks, when we talk about credit checks, we're really talking about the ability of someone to pay, right? And so is that your policy, once there is a change in the amount of the subsidy, does that automatically warrant a renewal or a reexamination of someone's income? And then the question then becomes is, if you're doing that, then does that necessarily now have an impact on a particular group?
Right. That makes complete sense. Yep. Anybody else, any questions, you can put them in the chat. If not, does that conclude the presentation, Dawn?
Yes, I mean, I have nothing, no additional comments to make, but again, I thank you, and I just really encourage everyone, like I said, to utilize the resources that LIBOR has and that are on our website and with New York State Division of Human Rights. And if you have any questions, then you should really reach out to contact us. And also, if you believe, or if you have a client you believe may be experienced discrimination, I would say don't try and figure it out for yourselves. There are experts that are here that are ready to investigate and make that determination. So the first step really is just picking up the phone or sending that email and making that inquiry. So again, Marianne, thank you to the audience. Thank you for the questions and for being attentive. I appreciate it.
Yes, Dawn, thank you so much for, saying yes, showing up, being here and sharing the information. Be well, and thank you all for listening in. Remember to go to lirealtor.com, Fair Housing Hub, for this information, more helpful resources, and thanks again.